A. Privity of contract. The principle of privity of contract means that a third party can neither be bound by nor enforce a term of a contract to which they are not a party, even though the contract was intended to confer a benefit on them. However, since the enactment of the Contract, Rights of Third Parties, Act 1999, such a party may be able to enforce contractual rights depending on the circumstances. If appropriate, it is now usual for contracts to include a clause which provides that such rights are not to apply. There are other ways in which a third party can be affected by the terms of a contract. A contract may be made by an agent on behalf of his principal. Such a contract may be enforced by and against the principal. It is usual for a contract to contain an express provision relating to assignment. The obligations under contract cannot be assigned, that is, transferred, without the consent of a party entitled to the benefit of such obligations. In novation of contract, a subsequent agreement between the original parties and a third party may have the effect of entirely replacing the original contract. B. Discharge of contract. Parties may be released from their contractual obligations, that is, may be discharged, by performance, by breach, by agreement, or by frustration. If a contract is substantially performed, the terms are entirely carried out and there is no right to repudiate the contract, that is, to reject it. If a contract is partly performed, a breach of condition is committed. However, if the innocent party accepts the partial performance, a claim to remuneration may be raised in a court. If there is defective performance, for example a condition is breached, the innocent party may have the right to repudiate the contract and treat it as terminated once he or she has communicated acceptance of the breach of contract. A contract may be discharged by agreement between the parties in a process known as accord and satisfaction. If it becomes impossible to perform, for example due to the non-occurrence of a particular event which forms the basis of the contract, or the death of a party, the contract is discharged by frustration. C. Remedies for breach of contract. An award for damages, money claimed as compensation for loss, is the primary remedy for a party who suffers a breach of contract. In some circumstances, the courts may use their discretion to compel a defaulting party to perform his contractual obligations. This is known as a decree of specific performance. It may not be appropriate if the obligation is not sufficiently clearly defined, or if enforcement would require the continual supervision of the court over a long period of time. In other circumstances, the court may grant an injunction to restrain a party from breaking the contract. In certain circumstances, for example, misrepresentation, parties may rescind, that is, cancel, a contract and by rescission be restored to the same position they were in before the contract was made.